Good morning, DZRJ, 8:10 a.m. The Voice of the Philippines proudly presents Piracy Watch with attorney Sarah Jane Sugitan, exploring the concepts of intellectual property rights and protection, teaching you how to protect what you create. And now, here's your host, Sarah Jane Sugitan.
Hello everyone, welcome to Piracy Watch. This program is being brought to you by the Intellectual Property Office of the Philippines with support from the World Intellectual Property Organization. This morning we're going to start a new segment called Juntahan, which is brought to you by the Filipinas Copyright Licensing Society. Last week, the question of the week for our Juntahan, and which we will answer today, comes from Dylan Kenji Uy of Nueva Ecija. Okay, Dylan says, I want to translate an English translation of a Pablo Neruda poem. Do I need to ask for permission, and from whom? Who owns the copyright to the three poems? Okay, the answer from the Intellectual Property Office is that the Filipino translator has to seek permission from the English translator, as the latter has independent copyright protection over the English translation. Pablo Neruda has copyright over the original Spanish version, the English translator has the copyright over the English version, and the Filipino translator has copyright over the Filipino translation. So there you go. If you want to translate any English or priorly translated work, you also have copyright over that particular work. All you have to do is to seek permission from the translated author or the author who did the previous translation in order to make sure that you will not be charged of infringement. Okay, moving on to some intellectual property alerts. Ford Motor Company sued luxury automaker Ferrari for trademark infringement after Ferrari named its 2011 Formula One racing car the F-150, no dash. In a complaint filed in federal court, Ford said Ferrari's F-150 logo bears striking resemblance to the one on Ford's F-150 pickup truck, the top-selling vehicle in the United States. Ferrari's choice of name marks the 150th anniversary of Italy and thus stands for Ferrari 150. The lawsuit is likely to be settled with Ferrari changing the name of its Formula One race car from the F-150 to F-150 Okay, moving on to the UK. The UK court upholds Hasbro's Play-Doh trademark. Hasbro Incorporated has obtained judgment in the United Kingdom High Court against 123 Narmital and its UK supplier Maps Toys for trademark infringement over the use of the trademark Play-Doh on their Yummy Dough product. The court found the defendants had infringed Hasbro's iconic Play-Doh trademark and passed off their products as being connected in some way to Hasbro. According to Hasbro's spokesperson, they are very pleased with the judgment, as it is Hasbro's practice to actively enforce its intellectual property rights globally. Hasbro owns the beloved brands Transformers, Little's Pet Shop, Nerf, Play School, My Little Pony, G.I. Joe, and Monopoly. Meanwhile, the World Intellectual Property Organization has released data which indicates that China is the world's fourth largest patent filer. According to the report, China's international patent applications reached 12,339 patents in 2010, up from 7,900 patents in 2009, thereby increasing by 56.2%. Wow, that's a lot of inventions. The top two Chinese companies who filed international patent applications were ZTE Corporation with 1,863 patents and Huawei with 1,528. According to the data, the United States, Japan, and Germany ranked first, second, and third respectively in global patent filings, with the US filing 44,855 patents, Japan 32,156, and Germany 17,171. Meanwhile, Elvis Presley Enterprises is filing multiple lawsuits in Florida and England on claims of copyright infringement and illegal sale of a DVD and CD box set of recordings and footage of the singer's performances. The Memphis-based company filed a copyright infringement lawsuit in the Chancery Division of the High Court in England and Wales against Joseph Perzada, alleging he is the source of the bootleg box set. The set includes footage from a 1977 television special called Elvis in Concert and raw footage of Elvis in Nebraska and South Dakota. Elvis Presley Enterprises manages the singer's music publishing assets and a worldwide licensing program. Meanwhile, India is all set to give hot yoga a cold shoulder. In order to stop self-styled yoga gurus from claiming copyright to ancient yoga poses or asanas like Bikram Chaudhury's hot yoga, India has completed documenting 1,300 yoga poses, which will soon be uploaded on the country's traditional knowledge digital library, making them public knowledge. Once the database is up online, patent offices across the world will have a reference point to check on every time a yoga guru claims patent on a particular asana. It is estimated that the U.S. Patent Office alone has issued over 200 yoga-related copyrights. Experts say yoga has become a $225 billion market in the West, with Americans supposedly spending about $3 billion a year on yoga classes. Yoga is a favorite among Hollywood stars Oprah, Madonna, Sarah Jessica Parker, Jennifer Aniston, Cameron Diaz, and Angelina Jolie. India's traditional knowledge digital library, which has 30 million pages of information, has been created to prevent those living abroad from claiming patent or copyrights for existing knowledge. The U.S. Patent and Trademark Office will soon open its express lane for patent applications with the launch of Track 1. The new system aims to speed up patent registration and bring the most valuable patents to market faster. Track 1 proposes a $4,000 fee per electronic application and hopes to clear the USPTO's backlog. On average, the examination of a patent application in the U.S. takes about 35 months before a decision is rendered. That's almost 3 years. Well, Track 1 examination aims to reduce that pendency time to 12 months. So, from 35 months to 12 months. For the first year, the USPTO will limit the Track 1 option to only 10,000 applications. Industries such as software and electronics, whose technology have relatively short lifespans, welcome the possibility of receiving a patent as quickly as possible. Track 1 is expected to go into effect next month. Okay, moving on to some local news. The Intellectual Property Office of the Philippines is set to open its 9th satellite office in Tuguegarao on February 19. Director General Attorney Ricardo R. Blancaflor will grace the opening ceremony. Now, for those of you who want to take their Masters in Law, the Ateneo de Manila School of Law and the Intellectual Property Office of the Philippines will be opening its LLM or Masters in Law program major in Intellectual Property Law. The LLM IP program is going to be pursued as an integral part of the ALS Masters of Law program as recognized by the Legal Education Board. The scholarships will be open and the program will be launched on school year 2011 until 2012. Okay, joining me this morning is Mr. Harry Tambuatco of Super Brands. Hello, good morning, Harry.
Hello, attorney. Hello,
okay,
attorney.
do it again. There you go. Okay, your mic is on. Again, for those of you who have not yet filed trademark applications or who have not yet registered your trademarks or brands, please do register with the Intellectual Property Office of the Philippines. We have a website at www.ipopphil.gov.ph. We have satellite offices all over the country. We have one in Baguio, one in Angeles, Pampanga, one in Legazpi City, Albay, one in Iloilo City, Cebu City, Cagayan de Oro City, Davao City, General Santos, and soon to be in Tuguegarao. So please file your applications for trademark registration because otherwise you don't own your brand. Okay, we'll be pausing for a short break. Do stay with us here on Piracy Watch.
We now return to Piracy Watch on DZRJ 810 AM, the voice of the Philippines. Here's your host, Sarah Jane Sugitan.
Hi everyone, welcome back. You're on the voice of the Philippines 810 RJAM. Meanwhile, let's have a traffic and weather update from Charlie of Traffic.com. Charlie? All right, you're still on the Voice of the Philippines, 810 RJAM, and you're on Piracy Watch with me, Attorney Sarah Sugitan, and joining me this morning is Mr. Harry Tambuatco of Super Brands. And of course, we're going to talk about what is pirated the most, trademarks, as usual.
No, Sarah, attorney, I find it peculiar that in Congress, for example, no, the extent of what you call trademark registration. How far do you go and what exactly do you register? I don't think the listening public are well aware. For example, iniisip nila, you need a product and a brand, a physical product like a shoe, a belt, a dress, a hair salon, that's a business trade name. No, it actually goes to anything that is of intellectual. Yes, services.
Any reputation, name, or
yun na nga, intellectual property.
Any brand. Not
So,
just what you use on products, products that you put on a shelf, but also products and services.
So, for example, party list groups, political party list groups, even NGOs, non-government organizations, quasi-governments, and whatnot. Many of them don't figure in registering it. Di ba nagiging problema? Look at Buhay Party List. Nag-away may-ari niyan, the former Ambassador Ray Señeres, and of course, Brother Mike. It was a celebrated case. It came out in the newspapers. It came out all over. Anong nangyari? Who exactly owns it? Who registered
The
it?
name.
Yes,
Buhay.
Buhay. Yes. And that goes for many party lists that a lot of lawmakers, imagine legislators, people with a mandate from the people, don't know that they have to register their group, their party list.
Yes, the brand of the party list with the trademark office or the
Oh,
intellectual
yun na nga,
property
hindi
office
nila
of the
naintindihan
Philippines. Yes, there is a distinction. Normally, NGOs or any corporation would register with the SEC or the Securities and Exchange Commission for the corporate name. And they think that is sufficient to own the name. Or usually when there's a corporation, they use the same name for the corporation as for the service or the product. But in some instances, the name of the corporation differs from what the company offers. So if it's a different name, nevertheless they should register both as a trademark. And definitely, the agency that you go to is not the SEC, not the DTI or the local government, but the Intellectual Property Office of the Philippines. Yan. So for not only for all party lists, all NGOs who are also in danger of being copied, you don't know, unless you own your trademark, unless you register it, you do not have ownership rights over it. So it would be in your best interest to own your mark. Otherwise, it will be hard for you to police or to order other people to stop or cease and desist from using or copying your trademark.
Here in the Philippines, the ability to copy is, it's rampant. It seems over the years it's been more of the practice and the norm rather than the exception. And people tend to do it. In fact, how about those titles that are what you call, that have metastasized or who become farcical? For example, I was in Pangasinan last week and there's a Kenny Rogers, as we very well know. And yet in Kamiling, may tindahan doon na manok. Ang tawag niya, Kina Rogers. Yung ganun, where does that fall in? I mean, can Kenny Rogers go to IP, for example, or go to court and say, ginagaya niya pangalan ko, Kina Rogers, Kenny Rogers. Pwede ba yun?
First of all, in order to seek legal remedies, you have to be registered. Otherwise, you really have no right. So the court will not entertain your case. It will say you have no standing to sue because you are not an owner. You don't have proper registration or documentation or a certificate.
So that's a perfect example then,
Yes.
attorney, na, well, for example, they wish to complain, they can't because wala, especially if they weren't registered. But if they were, pwede.
Oh, it's like land registration and intellectual property is a form of property. Unless you own registration or title to a land, court you cannot.
Wala kang
You cannot
personality.
file suit. Yes, you
No
have
legal
no standing
personality.
to defend the property because you obviously are not a party to that case. Pero
Ito,
yes.
let me extend it a little bit more. We have political families, I'm talking about the political side now, who have what they call trade names and brands. For example, the Singson family in Vigan.
Our president's family is also a brand.
The Aquino, the Cojanco family. You've got ang dami big families in this country. Now, they have become brands over years, especially when family comes in to take over or to become the sitting position, diba? Their children, their wives, their grandchildren over the years. And why not? There are a lot of big names. But these names, these family names, however some may call them